So the legislation creates administratively, legislatively, and then administratively, a second class of U.S. citizenship, U.S. citizens whose citizenship is called into question for completely political and ideological reasons. So you want to know why we oppose it? We oppose it because under the Equal Protection Clause and the Due Process Clause, we don't round up certain citizens considered second class and then subject them to administrative scrutiny that others don't have to.
This may look like a routine policy disagreement over immigration enforcement, but it's actually a stress test of constitutional boundaries. What's really being tested here is whether administrative power can be expanded in the name of security without eroding equal protection under the law. This raises broader questions about how far government authority can reach once citizenship and legal status are no longer treated as settled facts. In this video, we'll break down how a debate over fraud prevention exposes a deeper conflict between institutional accountability and constitutional restraint.
Committee reported favorably to the House. The clerk will report the bill.
H.R. 6978.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. McClintock, for an opening statement.
Thank you. Mr. Chairman, in recent weeks, our nation has watched in horror as several high-profile fraud scandals have come to light. Billions of dollars directed to helping those in need and funded by hardworking American taxpayers have instead been stolen by illicit fraudsters. In some cases, these schemes have involved foreign nationals or even communities with a large number of naturalized citizens. This has understandably raised questions about whether the same kinds of fraudulent criminal activity being perpetrated against our nation's generous welfare system are also being perpetrated against our nation's immigration benefits system. Indeed, in response to the massive amounts of fraudulent activity, the Trump administration has taken immediate action, pausing the adjudication of all pending immigration benefits for foreign nationals who hail from countries the administration has identified as being at a higher risk of likelihood that their nationals would pose a national security or public safety risk to the United States. Among the reasons a country might be identified as high risk are woeful inadequacies in screening, vetting, and the provision of information, such as criminal records that are widely unreliable and inaccessible, and widespread corruption combined with poor record keeping, resulting in any non-citizen being able to obtain any civil document from that country, particularly if that person is willing to pay a fee or engage in an individual who specializes in assisting such fraud. What they're already uncovering is shocking. In September, the Trump administration surged resources to review immigration applications in Minneapolis. This investigation uncovered evidence of fraud, noncompliance, or public safety or national security concerns in 44% of the cases interviewed. The cases included marriage fraud and forged documents. In addition to pausing the adjudication of pending immigration benefits requests, the Trump administration has ordered a re-review of all benefits issued from such high-risk countries since Joe Biden's Democrats opened our borders on January 20th of 2021. Such a requirement is essential to restoring the public's trust in our immigration system. This review will ensure a wide range of immigration benefits, from employment authorization documents to asylum applications and various visa petitions, or even naturalization applications, were not fraudulently obtained and that applicable standards were appropriately applied during adjudication. Mr. Finstead's legislation, the Preserving Integrity and Immigration Benefits Act, is simple and will codify this review process. Further, H.R. 6978 will ensure that both Congress and the public will be informed about what the administration uncovers. I can't possibly imagine why anyone would oppose this legislation. And again, I'm afraid we're about to find out. With that, I yield.
Would the gentleman yield?
We're on opening statements, but I'll get to you first.
Thank you.
When we get to member 5 minutes. The chair now recognizes the ranking member for an opening statement.
Mr. Chairman, thank you very much. On my way here this morning, I got a call from a constituent who was supposed to have her long-awaited citizenship interview, and she showed up at it, and the officer told her it had been descheduled with no explanation of why it had been descheduled. And that descheduling process has been the basis, actually, for then later attacking people's presence in the country as they're no longer on the schedule that they thought they were on. Well, this bill tells us just how much some people hate immigration in all of its forms, including legal immigration. I thought that was something that we could agree on. You know, it's always been my position we should make it much harder for people to get into America illegally and much easier to get into America legally. But this is an attack on immigration in all of its guises, including legal immigration. The bill purports to authorize a review of all immigration benefits, rights, and privileges approved during the last 5 years for individuals from countries that President Trump has unilaterally decided to place on his latest discriminatory travel ban policy, which includes the case of every green card holder who was issued a green card and every person who was actually granted citizenship. So the legislation creates administratively, legislatively, and then administratively, a second class of U.S. citizenship, U.S. citizens whose citizenship is called into question for completely political and ideological reasons. So you want to know why we oppose it? We oppose it because under the Equal Protection Clause and the Due Process Clause, we don't round up certain citizens considered second class and then subject them to administrative scrutiny that others don't have to go through. In fact, a lot of our Constitution is organized around the principle of settled expectations, which this legislation is designed to disrupt and to combat. Think about the Bill of Attainder Clause, which says that Congress can't just designate certain persons somehow as outside of the law. Think about the ex post facto clause, which is we don't go back and turn something into a crime after it's already happened. Think of the rule of naturalization itself. Congress has the power under Article 1, Section 8, Clause 4 to establish a uniform rule of naturalization, not one that is turned on and turned off according to the politically correct nature of the group that ended up getting citizenship or ended up getting a green card. And yet the whole purpose here is to designate an inferior group of people, separate and unequal, whose immigration benefits are actually not their immigration benefits necessarily, whose citizenship is not their citizenship necessarily, but must be subject to constant administrative probing and second guessing. So we are going to oppose this, Mr. Chairman, and I'm happy to yield back to you.
Gentleman yields back. Gentleman yields back. The gentleman from Tennessee is recognized.
We need to get on the ANS.
Oh, that's right. We got to do yes. The gentleman from California is recognized. Let me back up. Without objection, all of the opening statements will be included in the record.
What unfolded in that room was not just a routine exchange over a bill number or procedural language. It was a moment that cut to the core of how power is exercised in America. Congressman Tom McClintock stood before the committee and framed his case with stark certainty, pointing to financial misconduct, broken safeguards, and what he described as a system stretched past its limits. He spoke of reviews, of pausing decisions, of restoring confidence. His words carried the weight of accusation and urgency, suggesting that something fundamental had gone wrong and that extraordinary measures were now justified to fix it. Then came the response. Jamie Raskin did not begin with abstractions or statistics. He began with a phone call, a constituent, a scheduled appointment that suddenly vanished without explanation. In that small human moment, the argument shifted. What had been presented as a technical fix became, in Raskin's telling, a lived reality. Uncertainty imposed from above, rules changed without warning, and lives placed in limbo by administrative decision. This is the tension that defines so much of modern governance. On one side, the promise of order, review, and enforcement. On the other, the fear that these tools, once unleashed, do not stop neatly at their intended targets. McClintock argued that the Preserving Integrity in Immigration Benefits Act was simple, even obvious AMD straightforward. A review process, transparency, accountability. He asked aloud how anyone could oppose it. In his framing, resistance itself appeared suspicious, as if disagreement were proof of something to hide. Raskin answered that question directly. He said the opposition was rooted not in secrecy, but in principle. In his view, the legislation did not merely examine systems, it questioned people. It did not simply review paperwork, it reopened settled decisions. He warned that the bill risked creating a tiered version of belonging, where rights once granted could be perpetually re-examined based on political classifications rather than individual conduct. What we are witnessing here is not just a policy dispute. It is a clash between two visions of the American system. One vision prioritizes control and retrospective scrutiny, driven by the belief that past decisions were made too loosely and must now be revisited. The other vision insists that stability itself is a cornerstone of justice, that when the government grants a status, it cannot endlessly pull the rug out from under those who relied on its word. Raskin reached for the Constitution, invoking due process and equal protection. Not as slogans, but as guardrails designed precisely for moments like this. He argued that a nation governed by laws must also be governed by restraint, that Congress cannot single out broad categories of people for special suspicion without eroding the very uniformity it is tasked to uphold. His warning was clear. Once citizenship or legal status becomes provisional in practice, it ceases to be a guarantee at all. McClintock, meanwhile, spoke to a different anxiety, one felt by citizens who believe systems have been exploited, that oversight has failed, and that the public has been kept in the dark. To them, review is not punishment. It is reassurance. Transparency is not oppression. It is responsibility. From this angle, refusing to look back appears reckless, even negligent. And so the hearing revealed something larger than H.R. 6978. It exposed a country wrestling with the limits of trust. Trust in institutions, trust in processes, trust in the finality of government decisions. When trust erodes, calls for sweeping review grow louder. But when review becomes sweeping enough, trust erodes further. This time among those who fear they are being judged not as individuals, but as symbols in a political fight. The danger lies not in debate itself, but in what happens when debate hardens into absolutism, when every safeguard is dismissed as obstruction, when every review is treated as an attack. The American system was built on tension, yes, but also on balance. Enforcement without fairness becomes arbitrary. Fairness without enforcement becomes hollow. The challenge is holding both at once, without sacrificing one on the altar of the other. As the gavel moved on and opening statements were folded into the record, no final resolution was reached. But a truth lingered in the air. Laws do not operate in a vacuum. They touch real people, reshape expectations, and signal what a nation values most. Whether the future holds broader reviews or firmer protections, the choices made here will echo far beyond this committee room. Because at stake is more than administrative procedure. At stake is whether the United States remains a place where the rules, once applied, are honored consistently, or whether they can be reopened whenever political winds shift. It is about whether power is exercised with humility or with suspicion, whether justice is anchored in principle or in convenience. This is why these moments matter. This is why hearings like this deserve close attention. And this is why Liberty Report USA exists, to slow the moment down, strip away the talking points, and ask what these debates reveal about the country we are becoming. If you believe transparency matters, if you believe constitutional principles are not optional, and if you believe power should always be questioned, not assumed, support our work. Subscribe to Liberty Report USA and stay with us as we continue to expose the truth behind the politics shaping America's future.